Welcome everybody. This is the second in our series of talks about recent developments in DIFC law. And in this seminar, we're going to be talking about the conduit enforcement of judgments and arbitration awards through the DIFC, and also about the emergence of the Joint Judicial Committee, the JJC. The first one was on the subject of jurisdiction. And if you weren't able to join us last time, if you missed that one, then there is a recording that is available. There should be links on the websites, both of my chambers, 24 Old Buildings, and also of Rupert's chambers, Searle Court. But if you have any trouble finding them, then of course, just drop us a line. And we hope that you can join us for as many of the rest of the seminars as possible. Now, Rupert and I will be appearing in all of them, I'm afraid. Many of you will already know us. But just by way of very brief introduction, I've been working in the DIFC since it was established. I'm a barrister based in England, but the predominance of my work is still in the UAE. And that can be in the DIFC court or in arbitration, both inside the DIFC and outside. I've been in a number of the leading cases on a variety of the sorts of issues that we'll be discussing during the course of these seminars. And those include quite a few of the conduit enforcement cases that we'll be talking about today. Many of you will also know Rupert Reed, QC. He's also a silk practicing from Searle Court Chambers in London. He's been practicing, just like me, since very much the early days of this court in the DIFC, and a very significant part of his practice remains in the DIFC and in the wider UAE and also in the region. He's also appeared in many of the leading cases on a very diverse range of issues, including a number of the conduit enforcement cases that we'll be dealing with today. And he's also, I think, had a fairly close involvement in quite a lot of proceedings before the Joint Judicial Committee itself. In fact, I think one of the only times we've been in courts together at the same time, Rupert was on a conduit enforcement case where we were both on the same side. So we have that in our history. As I had explained at the last talk, the occasion for these seminars is the forthcoming publication of a new book that both Rupert and I have edited on DIFC law and procedure. And that will be published at the end of this month. And it does two things. Firstly, it provides an updated and expanded commentary on the rules of the DIFC court. So you'll have, in line with the rules, discussion of the cases that have dealt with each of those rules. And then in a separate section at the front of the book, there is an extensive commentary on various aspects of DIFC law. And as I said last time, the DIFC court has been gracious enough to endorse the book. And you will also see that both the Chief Justice and Sir Richard Field have provided us with some very generous forwards, and I take this opportunity again to thank them for that. And as always, we owe our debt of gratitude to Deputy Registrar Noor Hinadi and her team, who've worked really hard to help on that front. As I say, today's issue is going to be conduit jurisdiction and the Judicial Committee. And I'd say it's pretty hard to find a more controversial topic in DIFC law. And joining us today is the author of that part of the book, Harris Bohr, who we'll be talking to you in a moment. Harris is a senior junior barrister practicing from 20 Essex chambers in London. He also appears in arbitration, but he appears in litigation in both the DIFC and in English courts. And his practice covers a wide range of commercial disputes, including joint venture disputes, claims involving company law, and also fraud claims. He's also been involved in a number of the leading decisions on conduit enforcement in the DIFC. He's described in the guides as creative, thoughtful, clever, and a real fighter, which I can certainly attest to. But he's also said to be calm under pressure. So do sharpen up those questions for the end of the talk. So I'm going to hand over to Harris to let him introduce today's topic.
Many thanks, Tom. Good afternoon, everyone. I hope that you and your families are doing well in these difficult times. Can I first thank Rupert and Tom for inviting me to be part of the book project and to take part in this series of launch seminars. What is the purpose of history? probably not a question you expected at a legal seminar, but you'll see how it's relevant in a moment. George Santayana, the philosopher, thought that we should study history to learn from it. And he's the one who said, those who cannot remember the past are condemned to repeat it. And I would add to this that history also shows us the things we hold dear and want to keep hold of, and also those things that we aren't happy with and could do without. So in the first part of this seminar, therefore, I would like to present a short history of conduit jurisdiction and the Joint Judicial Committee, stopping on the way for some discussions with Rupert and Tom. And I later want to look at where we are now and where we want to be in the future. So turning to history, the year is 2004. Mark Zuckerberg is in his Harvard dormitory ready to launch Facebook. But more importantly, for our purposes, in that year, Dubai instituted the Judicial Authority Law number 12, the JAL. Now, by Article 7.2 of the JAL, the onshore Dubai courts became obliged to execute, number 1, judgments of the DIFC courts, and number 2, arbitration awards ratified by the DIFC courts. And this set up the possibility of the DIFC's conduit jurisdiction. Don't you just love that word, conduit? It's a way of moving or exchanging water, electricity, or information between places or systems. The hope for many was that the JAL would allow decisions made or recognized by the DIFC court to be enforced easily in onshore Dubai, thereby bringing together the DIFC court's modern international commercial approach to litigation with the well-established traditional court system of onshore Dubai. How was this supposed to work? Well, let's take arbitration awards first. In 2008, so the year the stock markets crashed, and the year the Large Hadron Collider at CERN came online, the DIFC implemented its arbitration law containing Article 42, which now states at Article 42.4 that awards recognized by the DIFC court may be enforced outside the DIFC in accordance with the Judicial Authority Law. So all you needed to enforce an arbitration award in onshore Dubai via the DIFC was to apply for recognition and enforcement of the award in the DIFC court under Article 42 of the DIFC arbitration law, and then to apply in the onshore Dubai court for execution of the award under Article 7.2 of the JAL. In 2013, Nelson Mandela and Margaret Thatcher died, and Deputy Chief Justice Sir John Chadwick in AVB confirmed that the DIFC court had jurisdiction to enforce a foreign award, and that's whether or not the defendant had any assets in the DIFC and whether or not there was any other connection with the DIFC. In 2015, the Court of Appeal in Meydan and Banyan Tree found that this applied even where the seat of the arbitration was onshore Dubai. The award in Banyan could be passported from the DIFC back to onshore Dubai from where it came. Now, there was some real unease at these decisions. From 2013 to 15, there was a series of cases where complaints were made that the DIFC court's approach was unconstitutional or a breach of public policy. And the cases here include Fisk and Firuza, Banyan Tree, Meydan again, and Egan and Eva. The DIFC court rejected these arguments, and I think that the DIFC court was right to do so. The law is clear, and I also take the view that arbitration awards should be enforced, and the DIFC court judges, as specialists in international commerce, are well placed to assist with that. In 2014, I was instructed to resist enforcement through the DIFC of an English High Court judgment in the case of DNB Bank and Gulf Edaya. The defendants' evidence was that they had no assets in the DIFC, and more importantly, they had no intention of bringing any assets into the DIFC. My clients, the defendants, contended that the sole purpose of the claimant's claim was to circumvent the requirements of UAE law and to obtain enforcement in onshore Dubai via the DIFC. Now, I made these points, explained why my case was different to Banyan and why litigation is different to arbitration. The court nevertheless found against the defendants, as indeed did the Court of Appeal in 2015. The DIFC, it seemed, wanted to expand its caseload. It would take jurisdiction wherever it could. In making its decision, the DIFC Court of Appeal confirmed that it has the power and jurisdiction to enforce foreign judgments pursuant to the court law, Article 24, and or the Judicial Authority Law, Article 7.6. Any relevant treaty would also be applied. Subject to that, said the Court of Appeal, the DIFC court should apply general common law principles in considering whether to enforce a foreign judgment. Now, you might recall that by this time, there was also a non-binding memorandum of guidance dealing with enforcement between the DIFC courts and the English Commercial Court, under which each side expressed its intention to respect one another's judgments, subject to limited exceptions, including where a judgment was procured by fraud or where enforcement would be contrary to public policy or natural justice. So as a result of DMB, the floodgates were opened. The court took a similar approach to its conduit powers in Bossamer and Emirates Trading in 2015, and in Barclays Bank and ESSA in 2016, a case involving a $190 million New York judgment. Meanwhile, criticisms of the DIFC court's approach abounded. In respect of foreign judgments, the point was made that the effect of conduit enforcement was to permit the enforcement of judgments in Dubai and possibly from there further afield, which the Dubai court would not itself enforce directly. So, for example, a UAE court might have no treaty for the mutual recognition and enforcement of judgments with a particular country and refuse to enforce an award from that country, but be compelled to do so by the DIFC exercising its conduit jurisdiction. Now, personally, I have some sympathy with this complaint and can see why the DIFC court's powers to enforce foreign judgments to be more problematic than its powers to enforce arbitration awards where an international regime, like the New York Convention, has been agreed. Others, however, also criticized the DIFC's approach to arbitration, particularly in relation to onshore Dubai domestic awards. The DIFC's decisions meant these could be imported to the DIFC and then exported to onshore Dubai, where they came from. The point was made that this was an abusive practice intended to circumvent any application to set aside the award in the Dubai courts as the courts of the seat. I'm going to pause my survey here and we'll simply note that the law as far as the DIFC is concerned hasn't really changed very much. So we're up to 2016. Tom, Rupert, over to you.
Well, yeah, thank you, Harris. I mean, it's Rupert, it's been interesting, I think, and maybe you share this view, to track the development of the conduit jurisdiction in the DIFC courts. As Harris says, that's obviously come in stages. So first we had all the cases relating to foreign awards. Pretty quickly in the course of that, we saw the Banyan case dealing with a domestic award being onshored and then offshored again, or offshored and onshored again. And then finally, we had the DMB case in the Court of Appeal where we managed to succeed for the conduit enforcement of a foreign judgment. And at first, as Harris said, there's tremendous resistance to all of this. But for me, the consensus, it seems, at least among the common law practitioners, seems to be coming round to the view that conduit jurisdiction for foreign awards, at least, is acceptable. And actually, we've seen, haven't we, recently, a decision from the ADGM court in Abu Dhabi, recently permitting the enforcement of a foreign award in the ADGM without proof of assets, where the similar sorts of complaints were being made, that this was an exercise in conduit enforcement and so an abuse. Interestingly, in that case, I saw there was no mention of actually the DIFC court decisions. So they didn't apply or even appeal to DIFC case law, although in my view, slightly curiously, there was reference to one of the JJC decisions in that case. But the ADGM's independent conclusion, at least, or is at least consistent with this approach to conduit jurisdiction, conduit enforcement of foreign New York Convention awards. But despite that, it seems to me the DIFC court's approach to domestic awards and foreign judgments has remained extremely controversial. And I've heard all of this being described in some parts as judicial activism, and Harris put it in terms of taking jurisdiction wherever they could. Do you agree with those criticisms?
I do. I think I'm probably a little bit more conduit sceptical than you are, Tom. I can see the public policy issues. I always thought there were public policy issues raised in the Banyan judgment, where you got an award coming in from Dubai, where the arbitration was seated, into the DIFC, then boomeranging back out of the DIFC, back into the Dubai courts for enforcement at a time when there was a challenge in the Dubai courts. That did seem to me to raise issues of public policy. I've always felt quite strongly that the better filter is, rather than the sort of binary approach of conduiting yes or not, would be actually the IPCO approach. The jurisdiction of the court to grant a stay, which it has under Article 44.2 of the arbitration law, the DIFC arbitration law, because that involves a much more sophisticated analysis of the challenge, of the prospects of the challenge, of the good faith or not of the challenge, of the length of time that's going to be involved. And it's a balancing, essentially, of a comity between the relevant courts and support for arbitration, making arbitration work. The courts have applied IPCO in a number of cases. They've considered it in Eber and Egan. They considered it in Auger and Daman, and they in fact applied a stay. They ordered a stay. Justice Chadwick ordered a stay in the Fabiola and Fadi case. And that seems to me to open up a discretion, which is a much more sophisticated tool, because as you'll remember in Banyan, one of the things that Steele did in the early judgments was essentially eliminate the discretion which some thought existed under the wording of Article 42 and 44 of the Arbitration Act. And the other filter, I think, is as you mentioned, this whole issue of whether there are assets in the jurisdiction. Many of us felt, in terms of why we felt doubt about the conduit jurisdiction, when one looked at the JL, the schema of Article 7 of the JL, when you were bringing judgments or bringing awards, into the DIFC, under 7.4, which started with the words where the subject matter of enforcement is situated in the DIFC, and in the same process you were then taking it back out of the DIFC under Article 7.2, which started with the words where the subject matter of enforcement is situated outside the DIFC. So there was a certain discomfort in using both of those provisions in the same procedure. What then started happening was you started getting applications to use the conduit on the basis of, well, we've identified some bank accounts in the DIFC, when everyone knew that the real enforcement target was in Dubai, not in the DIFC. So it seems to me that is a discretion which allows some consideration of where the relevant assets are is important. Although, as I would recognise, it's very difficult given the current case law. I would just say in relation to that where we are now very often are conduiting, if you like, worldwide freezing orders, WFOs. So we're getting the worldwide freezing order in Dubai, and then we're taking it through the conduit into Dubai. Obviously, in that circumstance, in that situation, there has historically been a requirement of assets in the jurisdiction, i.e. in the DIFC, and that requirement has to some extent been eroded recently. And there was a recent decision, CEBD and Shetty, where Mr. Justice Wayne Martin said that the cases show that there's no need to show assets within the jurisdiction for the exercise of extraterritorial jurisdiction, although that does play into the discretion, obviously, as to whether a freezing injunction is going to be ordered in the DIFC. So those seem to me to be better ways of deciding whether it's appropriate for judgments to be recognised and enforced in the DIFC, or whether there should be a stay pending any challenge. And of course, the stay approach is consistent with the approach in most common law systems in relation to judgments. Certainly the Brussels Convention approach, the Hague Convention approach, and the common law approach, where essentially an appeal of the original judgment. It proceeds before recognition enforcement, or at least there's a discretion to suspend.
Thanks. I mean, my view, for what it's worth, is that in relation to foreign arbitration awards, the legislation certainly, it seems to me, permits conduit enforcement. And indeed, on one view, it's been drafted specifically to allow that. And so these accusations of judicial activism are actually the reverse. I think really what's being said is that there should have been judicial activism in an effort to confine really what is otherwise the plain meaning of the legislation. I can see that there are different arguments in relation to domestic awards and foreign judgments. For domestic awards, I think there must be a sense in which this is an unintended consequence. I'm not sure I agree with the analysis based on abuse of process or on the basis of the need for assets in the DIFC. But I do agree with you that there's no particular reason when the court's considering a stay of enforcement in circumstances where there's a set-aside application in one of the local courts in the Emirate. There's no particular reason why that can't itself be a discrete and important feature in deciding whether there should be a stay, and if so, whether there should be conditions to that stay. And actually, in quite a lot of the cases, there have been stays, as you mentioned one, but indeed, the sort of epicenter of this, the Oja and Daman case, there was a stay. It's just it was a conditional stay requiring that money be brought into court as a condition of the stay, and of course the money wasn't brought in. So I think applying a somewhat more flexible approach, perhaps, and taking a bit more stock of the fact that the challenges in the Emirate could have led to this whole situation being avoided. I think in relation to foreign judgments, there are, it seems to me, more technical arguments that could have been raised against it, and that could have been alighted on by the courts. But I mean, ultimately, actually, a lot of the discussion of this, and a lot of the opposition to this is in fairly emotive terms. And in my view, quite a lot of it loses sight of the basic point. By the time you've got your foreign judgment, if it's a regular judgment, you've already fought the case, you've already won the case. And so for me, anything really that allows parties to enforce a regular judgment is a positive thing. But I do quite accept that not everybody sees it quite that way. And obviously this has had some impact, and the JJC has been part of that. And I think Harris is going to go on and explain a bit about what happened next.
Great. So I'll continue. I think I'm in 2016. On the 9th of June, 2016, so that's just a few days before my wife's birthday, note to self, Dubai Decree number 19 was issued. This established the Joint Judicial Committee, the JJC. Its purpose, broadly, was to resolve conflicts of jurisdiction between the DIFC courts and the Dubai courts. The JJC decisions impact the DIFC court in several ways. First, in terms of composition. Nominally, the JJC is composed of 7 members, but in practice, 6 members sit. So there's 3 judges from the DIFC courts and 3 from the Dubai courts. The JJC is quorate with just 4 members. Where the committee members are split equally in their decisions, the deciding vote is given to the president of the Dubai Court of Cassation. Now, the effect of the JJC's creation, therefore, was to effectively confer on the Dubai court judges the right to overrule the DIFC court judges. That is, where they differ on which court should have jurisdiction. So that's one impact. The DIFC court is also impacted by the JJC because under Decree number 19, the JJC must stay its own proceeding once any application to the JJC has been made. In terms of the broader impact, I don't think it's an exaggeration to say that the early JJC decisions put a great big stick in the spokes of the wheel of Conduit and other DIFC jurisdiction. So, for example, in Daman versus OJ of 2016, the JJC found that the DIFC proceedings to recognize and enforce an arbitration award made in an arbitration seated in onshore Dubai had to be stayed where there were annulment proceedings in the Dubai courts. The DIFC courts were directed to cease from entertaining the case. The DIFC judges gave short dissenting decisions in the JJC in which they essentially pointed out that there was no conflict between enforcement in one court and annulment in another court. And I think that's correct. An enforcing court has a right to consider enforcement of an arbitration award despite annulment proceedings in another jurisdiction, even if that other jurisdiction is the seat of the arbitration. If the court considering enforcement thinks those annulment proceedings might succeed and be relevant, it can stay its own proceedings. In Dubai Waterfront versus Liu of 2016, the JJC found that the Dubai court alone had jurisdiction to determine the validity of a DIAC arbitration award. And that's another decision which to me just doesn't seem right. There were some cases rejected by the JJC, but these involved situations where there was no competing claim in Dubai, so easy, or where a claimant had conceded jurisdiction at first instance, so again, an easy case. And what this meant, of course, was that defendants in the DIFC court simply started proceedings in the Dubai courts, seeking the reverse of whatever they claimed in their defense in the DIFC courts. And this was very good for lawyers. Two sets of pleadings, where there might be just one, actually three sets, including the JJC. In 2016, I was instructed in Gulf Navigation versus Jinhai to resist an application in the DIFC court to stay enforcement of a London arbitration award. The other side had brought a cross-claim as a fresh arbitration and wanted a stay in the DIFC enforcement proceedings for enforcement of the original arbitration award. The applicants had also previously applied unsuccessfully to the English courts to set aside the award, so you get a feel for this case. On the facts of the case, the DIFC court had no difficulty whatsoever in rejecting the application for a stay. Some of you will be familiar with the case because you instructed me on it. I flew home thinking that the job was done, but it wasn't the end of the matter. Gulf served proceedings before the Dubai Centre for the Amicable Settlement of Disputes, wanting an expert to consider the arbitration. The centre apparently is affiliated to the Dubai courts. Gulf then applied to the JJC, alleging that the DIFC court lacked jurisdiction to enforce the award. And so in 2017, when North Korea tested its first successful intercontinental ballistic missile and Emmanuel Macron was elected as French president, a JJC majority found that there was a conflict of jurisdiction in my Jinhan case. They said the onshore Dubai courts should decide the case since the Dubai courts have, and this is a quote, general jurisdiction. And the New York Convention was said to be irrelevant because the choice was between courts in the same emirate. The JJC's decision was problematic, to say the least. As the DIFC judge's dissenting decisions made clear, it flies in the face of the New York Convention on enforcement of arbitration awards. And furthermore, by Article 8.6 of Dubai Law Number 9 of 2004, the DIFC court's jurisdiction is exclusive and so can't be shared with the Dubai court. One might also ask, particularly in this context then, what is meant by the term general jurisdiction? The term appears in further 2017 JJC decisions, which found a conflict of jurisdiction between the DIFC and onshore Dubai courts. The JJC also found in such cases that the Dubai court should deal with the matters. I'm referring here to cases of Endufa and Bosima. Not all the challenges to the DIFC court's jurisdiction, however, succeeded. So, for example, in Assas, the JJC found that there was no conflict caused by an application being made for execution of an arbitration award in both the DIFC court and Dubai court, which I think must be right. For further examples of JJC decisions in 2017 or 18, you're going to have to buy the book. Tom or Rupert might want to comment on them in a moment. For now, I'm just going to leave you hanging like the end of one of your favorite dramas on Netflix. So let me just sum up where we're up to. Until 2019, the general picture was that where proceedings were up and running in both the DIFC court and Dubai courts, the JJC tended to favor the Dubai court over the DIFC court, unless, that is, there was clear evidence that a party had voluntarily submitted to the DIFC court's jurisdiction. So before turning to where we are now, Tom, Rupert, again, any comments at this stage?
Yes, thanks very much, Harris. I mean, and that's very helpful. I think it takes us up, Rupert, to the end of 2018, really. And I don't know if you agree with me on this, but at that point, it was still starting to look pretty bleak. I think the early decisions had perhaps indicated that, certain types of conduit jurisdiction would survive, particularly those where there was no obvious corresponding claim that could be made in the Dubai courts. But then even that hope rather dissipated subsequently as you saw the emergence of claims in the Dubai courts for negative declarations in relation to the enforcement of foreign instruments. And so, as I say, the position looked like kind of wholesale interference in not just this area of DIFC law, but the potential to spread wider. I don't know whether you agree. What are your views?
My recollection was a sense of grim resignation when one read the minority dissenting view, which was repeated time and time again about the importance of Article 7 and the New York Convention and the rest. In no sense was the DIFC court or the dissenting minority cowed by the logic of the majority judgments. In no sense did they accept them as being binding. They were soldiering on. There was a certain amount of spirited resistance from the DIFC court. One saw this perhaps in the cost orders that were made, certainly in Standard Chartered and IGPL, and also Barclays and Kapoor. But they were pretty limited. They were limited to circumstances where an application to the JJC was made relatively late in the day. Indeed, in the Barclays and Kapoor case, I think it was 4 days before the trial, an application was made to the JJC, and Mr. Justice Field ordered indemnity costs on that basis. There's also, again, in the last decision in 2018, a spirited resistance from Mr. Justice Field. You probably remember the VIH decision, commonly seen as a decision on the contempt jurisdiction. But essentially, the court said in those circumstances, in that case, that if you were on the wrong end of an interim injunction obtained ex parte, the fact that you were prevented, that the return date was adjourned generally, and the fact that you couldn't go back to court under your liberty to apply was a risk that you had taken in filing an application in the JJC. So there's a little bit of a twitch of resistance, if you like, but the atmosphere very much seemed one of grim resignation to the majority rule on the JJC.
Yes, and it seems to me that the introduction of the JJC had and still has to some extent, it bears the risk of really fundamentally undermining the purpose and function of the DIFC and the DIFC's court, because part of the aim of establishing an international commercial court is to ensure that it functions independently of the other courts in the state. Now, you may have views or otherwise of the relative qualities of international judges, but that's not really the issue. What matters, it seems to me, and the purpose of it all, is the way in which international business perceives the jurisdiction. And one of the ways that you attract international business is you establish a court which cannot be controlled by government or by the local judiciary. And the effect of the JJC, I think, has at least the potential to really undermine that, because if you are able to say which cases belong in that court, then you are able to control the outcome of those cases. And you see some perhaps slightly surprising decisions which were taken from the hands of the DIFC judges into the hands of the Dubai courts. And none of that is really assisted by the fact that, as you said, as Harris pointed out, you have this kind of repeated mantra in the dissenting judgments explaining in quite a clear way why there's no conflict, for example, between enforcing, on the one hand, in the DIFC, and enforcement and annulment proceedings in the Dubai courts. And repeatedly explain that, and there's never an answer to that. There's never really any logical engagement with that in the majority decisions. And then, as Harris mentioned, there's this emergence of this concept of the general jurisdiction, which seemed to threaten even further the concept that the DIFC was genuinely independent, because what seemed to be said was, well, if you can just about justify there being claims in both courts, then it'll always be the case that the Dubai courts will take jurisdiction. So there were real concerns there. And I also tend to agree with you that, the DIFC court tried to do something about this in some ways and made certain attempts using its own orders. But ultimately, there's a limited amount that it's actually in a position to do. And I remember doing a case in front of Sir Richard Field, and we were trying to bring a claim And part of the defence, or part of the response on jurisdiction, was that there was an English jurisdiction agreement there. And part of my argument on that was, well, look, what happens if you enforce that English jurisdiction agreement? We go to England, we get our judgment there, then what do we do with it? You know, we're going to come back and we're going to have to start the process again. And in his judgment, Sir Richard Field accepted that the JJC was hostile to conduit enforcement, and that formed part of his reasoning there. Now, it seems to me that on that front, at least, things have moved on quite a bit, and there's been a change of personnel from both sides, from the DIFC and from the Dubai court side on the JJC. And I think Harris is going to come on and tell us a bit more about where things have moved to now.
Yeah, I mean, we get to a happy place now, Tom, because we're really into a bright new era. In 2019, as you say, the composition of the JJC changed. And since then, the vast majority of decisions have been in favor of the DIFC retaining jurisdiction. So just to give you an example, in National Bank of Kuwait and KBM, the bank claimed that the DIFC did not have jurisdiction over it with respect to a freezing injunction and commenced proceedings in the Dubai court. The JJC disagreed with the bank. The freezing injunction involved a facility agreement which was to be performed in part in the DIFC, as repayments were to be paid into an account there. The JJC also found it relevant that the Dubai court had issued an order enforcing the DIFC court order. Then in 2019, there were JJC decisions in which the committee also confirmed that it will enforce an express jurisdiction agreement in favour of the DIFC court. So good news. Thinking of the case of Oman Insurance and GlobeMed, there have also been cases dealing with the old chestnut of whether the courts of Dubai or the courts of the United Arab Emirates point to or include the DIFC court. In Al Rafi and Commercial Bank of Dubai, the JJC appeared to accept that an agreement in favour of the courts of the United Arab Emirates could confer jurisdiction on the DIFC court. However, the case which perhaps signals the most positive development as far as DIFC jurisdiction is concerned has to be, I think, ESSA Projects and McConnell. In that case, the JJC expressly rejected the notion that the Dubai courts had general jurisdiction. The case is also significant as it appears to cover a conduit jurisdiction case. The JJC and ESSA also took a more robust stand against frivolous petitions than it had in the past, something I know which we're all concerned with. The claimant sought to enforce a Singapore judgment in the DIFC court. The defendant disputed jurisdiction and brought a claim in the Dubai courts seeking an order setting aside the Singapore judgment. The JJC dismissed the petition and lifted the stay on the DIFC proceedings. It didn't, however, impose a stay on the Dubai proceedings, finding instead that the petition to the JJC was premature as the DIFC had not yet made its decision. Now, although the case is welcome, it does leave open the question of the right time to apply to the JJC, which maybe someone will comment on. So to sum up, where are we now on the JJC? I have just 4 points on that. First, there's going to needs to be conflicting proceedings before the DIFC court and Dubai courts, before the JJC will entertain an application. Secondly, if a party has accepted jurisdiction of the DIFC or expressly chosen the DIFC court in a jurisdiction clause, the JJC is now likely to uphold the DIFC's jurisdiction. Thirdly, the JJC is unlikely to find that there is a conflict between the DIFC court and Dubai courts in matters involving interim remedies or where execution of an arbitration award is sought in both jurisdictions. And fourthly, and perhaps most importantly, the JJC's initial hostility, which we've spoken about, towards conduit enforcement proceedings seems to be softening. So as matters stand, therefore, it is appropriate to use the DIFC court as a conduit jurisdiction, or possible. And the cases I spoke about earlier, Banyan, DAB, etc., they're all relevant to this. There are obviously other points which I could make on the JJC, but those are the headlines. So let me hand back the floor to you at this point again for the because I think we've got some questions that people have asked.
Yeah, and I mean, Rupert, his question. I mean, for my part, it's obviously pretty striking the change in 2019. The change of personnel, as I said, on both sides. And it's striking that of all of the decisions that we've seen since then, only one has found that the DIFC court does not have jurisdiction and that the Dubai court should take over on a case. And even that was a unanimous decision. So the DIFC court judges also agreed with that conclusion. I mean, what are the most significant changes that you've seen in the 2019 decisions?
Well, as you say, very much return to conduiting. I mean, as Harris mentioned, the SR Projects and McConnell case was essentially a formal reopening of the judgment conduit. The language of the JJC in that case, finding that the DIFC court's jurisdiction was overwhelming, declining to make any reference to the general jurisdiction which had been alleged to the Dubai courts, and attacking the judgment debtor's conduct as having dragged the claim out, cynically and discreditably attempting to escape an undoubted obligation. I mean, really extraordinary language. And that, as Harris mentioned, followed very much in the tail of the State Bank of Mauritius case in which I was involved, which, again, politically, it was very sensitive. The freezing injunction was sought against the National Bank of Kuwait, the Dubai branch of a Kuwaiti bank, an onshore bank. And obviously, there are huge political sensitivities in respect of asset disclosure and freezing assets in onshore banks. But the JJC had no trouble recognizing DIFC court jurisdiction. There was a wrinkle in that case in that the DIFC court order, the WFO, had already been enforced in the Dubai court, so it was a slightly odd application. But that decision is now the basis of numerous attempts to take worldwide freezing orders from Dubai from the DIFC into Dubai with a view to freezing assets in the hands of Dubai onshore banks and the UAE onshore banks, and getting the sort of asset disclosure that accompanies a freezing order. So that both those decisions are very significant. One of my frustrations I find in practice is that one so often gets London solicitors, London firms coming asking for advice about how they can freeze assets in Dubai, often Saudi assets or Emirati assets in Dubai. And they're still caught in the mindset of the JJC and that the conduit is broken and that the conduit isn't available. The contemporary advice is that the conduit is very much available, not least in view of these 2019 decisions by the JJC.
So is your view then that in effect, you know, the damage that's been done by the JJC or the difficulties posed by the JJC is solved by this change of attitude?
It's never as simple as that. I mean, there's an economic calculation, isn't there? The court fees for using the conduit are significant. If there is a real chance of using the conduit effectively, then those court fees are obviously very good value for money in most cases. If the conduit is broken, as it had been certainly in 2017 and 2018, then parties were shying away. The economics of using the conduit didn't appear to work. But I would hope now that we've passed a tipping point on that.
Well, we're probably trespassing into some of our questions. Firstly, thanks very much, Harris, for that presentation. It's really, really interesting and helpful in framing the debate in particular. But I think that we have elicited some questions from people, and I think those, Rupert, you've taken custody of them.
Yes, I think I'm quizmaster for the day. And the first question is from Ben Bruton. Will the new UAE arbitration law reduce the appetite for litigating to use the conduit? And I should, before I start, can I roll into that?
Sure.
A related question from Michael Black is: should we still use the conduit for New York Convention or foreign awards? And why wouldn't we just go directly onshore?
Yeah, I mean, I think part of the problem of conduit enforcement has certainly appears to be easing with this SR Projects decision, in particular in the JJC. But I think you still will have the problem of the JJC. At the moment, there is still scope for making JJC applications, and the immediate impact of a JJC application is a stay of all proceedings. And at the moment, as I understand it, for various reasons, the JJC hasn't sat for a little while. So if you had started your conduit enforcement case at the beginning of this year, you will have not made any progress on it if the other side chose to press the JJC button. So I think that will always be in the background. I think the UAE arbitration law has obviously been developed to try to introduce a more arbitration friendly, a more user friendly approach to the enforcement of arbitration amongst other matters in the UA. And I'm not an expert on that particular piece of legislation, although I have had some dealings with it. And I think that from my discussions with lawyers, there's still a degree of nervousness about it. It's new. There is therefore a question about how aspects of it will be interpreted and applied. And I am aware of cases which have gone wrong despite the new arbitration law on these age-old issues, for example, of whether or not a party, the individual who signed the arbitration agreement, was authorized to enter into the arbitration agreement. So if the UA arbitration law, the new one, is not solved even that age-old bugbear, it seems to me that there will always be questions about whether it will really genuinely provide a complete solution. And so I suspect that there will be, in a case that's worth it, simply a belt and braces approach, albeit that's the expensive approach, so it will take the case, need the case to be worth it, of possibly pursuing all avenues for enforcement. So I think that in answer to Ben's question, will it reduce the appetite for litigants to use the DIFC courts? I think it probably will, but probably not a lot. Can you still, in Michael's question, can you still use conduit jurisdiction for a New York Convention award? It looks like you can, but we're still working through the problems, and we'll just have to see. And of course, all of this appears to have changed quite considerably as a result of the change of one or two members of the JJC. And it's obviously quite possible that those memberships will change again in the future, and attitudes will change. And so clients need to be made aware of all of these sorts of risks, it seems to me.
So in terms of the circumstances that have precipitated the 2019 change, I think we've got the change of personnel in the JJC, we've got the UAE arbitration law, and Peter Smith, in a question he's asked, raises a further one, which is he raises the Cabinet Resolution number 57 of 2018, which is effectively an amendment of the CPC and Article 85. And whereas it used to be the case that there was a bar to the enforcement of foreign judgments if a dispute was capable of being litigated in the UA courts, the new Article 85(2)A provides that the bar is only if the UA courts have exclusive jurisdiction over the parties or subject matter. And Peter wonders whether that may have had any impact on the decisions in the JJC.
Yeah, so again, I mean, this is looking at the question of conduit enforcement of foreign judgments, which, as I said, remains controversial. And I'm not sure we've seen necessarily changes in the JJC's attitude specifically in relation to that, albeit one might extrapolate from the SR decision in relation to arbitration awards. But yes, as I understand the change in the onshore legislation, whereas before the UA courts would not enforce a foreign judgment if they might have had jurisdiction over that claim. Now they will not enforce the foreign judgment if they might have had or would have had exclusive jurisdiction over that claim. And so that often in the past was really the reason why people wouldn't bother to try enforcing foreign judgments in Dubai, because the Dubai courts would say that they had jurisdiction if, for example, the defendant was based in Dubai or had assets there, and therefore most of the circumstances which would justify taking the action in the first place would also mean that it was unlikely that your judgment would be enforced. Now that has changed, but it's not the only restriction on enforcement. And I had thought that this would also would open up enforcement generally, and I think it has that capacity. But there are other restrictions which. So when I was dealing with quite a heavy case and we looked into this, the advice coming from local lawyers seemed to be that could solve this particular problem, but they still had the problem of persuading the Dubai courts that the English courts, for example, if you're dealing with an English judgment, would themselves enforce UAE judgments, Dubai court judgments, in the absence of a treaty. So they were having trouble coming to terms. I think Michael Black had a funny story about trying to produce some commentary from Lord Collins, for example, who obviously is the leading jurist, one of the leading jurists of recent years on these sorts of questions, and finding that the local courts were just simply not interested in hearing about that sort of thing. And I know that there were problems encountered in the Ahmedova litigation, and certainly problems were predicted in my case, even though there had been an amendment. I know that there are cases where judgments from, I think from England, have been successfully enforced. So it is a mixed bag. I think it will affect the way in which people approach these issues, but rather like the answer to the previous questions, I'm not sure it provides a complete solution to this problem.
I mean, I always felt that when the JJC talked about general jurisdiction, and sometimes they refer to it as original jurisdiction, it was in a way a rather simplistic assertion that the underlying dispute should have come before the Dubai courts. And in a way, that's why I suspect Peter may be right, that this restriction of the jurisdiction not to enforce a foreign judgment may have had some effect in terms of the judicial mentality and the judicial culture in the UAE.
Interesting.
Who knows? Right. We've got one more question from Mohammed Mahmoud. A really interesting one. What preemptive action, in brackets, if any, can be taken by an award creditor, presumably with a view to ensuring that the JJC doesn't stay proceedings in the DIFC court?
So I mean, we touched on this previously. I mean, what can the DIFC court do to stop people from going to the JJC? And we've seen a number of attempts. Some of them, well, none of them particularly successful, it seems to me. So you mentioned, Rupert, cost sanctions. I think in the IGPL litigation, the then Deputy Chief Justice, David Steele, attempted to use his own case management powers within that case, in effect, to extract an undertaking from the defendant not to go to the JJC. They hadn't, I think it was, they hadn't pleaded their counterclaim in time, so they needed his permission to introduce a new counterclaim very late in the day. And so the way that he did it was he said, well, I'll give you that permission, but only if you promise me that you're not going to go off to the JJC. And of course, the defendant in that case was extremely critical, and it had absolutely no impact at all. I think they went twice to the JJC pretty much on the same grounds. I think in many ways, the JJC was an attempt to try to solve the problem of parallel proceedings in the Dubai courts and the DIFC courts. So right in the early days, this problem has arisen right from the beginning. Right in the early days of the DIFC courts, I appeared in an attempt in the case called Talim to prevent the defendants from bringing parallel proceedings in the Dubai courts. And we launched that as an anti-suit application. And there are parallels to be drawn between that situation, the DIFC courts, and the very early days of the English courts of chancery, when the anti-suit was in fact invented. And Sir John Chadwick wasn't willing to listen very much to that sort of argument at that stage in the history of the DIFC. So in a way, the JJC is supposed to be doing the job of ensuring that there aren't parallel proceedings. And so ultimately, I agree with what you said when we were discussing this earlier, that my sense is that there's been a sense of resignation amongst the legal community and also amongst the judges, that there's not an awful lot that you can practically do other than threatening cost sanctions, and if the circumstances are appropriate, seek debarring orders potentially in the course of the proceedings.
If you did get an ASI, an anti-suit injunction, you would essentially be asking the Dubai Attorney General to sanction recourse to the Dubai courts and to the JJC. So you'd be potentially putting him in an extraordinary position, which leads me to think that the DIFC courts, which are generally speaking have accepted their jurisdiction to give anti-suit relief, but haven't actually ordered it very often, would be very reluctant to use anti-suit relief to prevent proceedings being brought in the Dubai courts with a view to then preventing the JJC having any jurisdiction. So it seems unlikely in practice that the ASI would actually have the desired effect.
I think that's right. I mean, it's interesting. I mean, I've advanced a number of anti-suit arguments, some of them aimed at Dubai court proceedings, and I've resisted applications for anti-suits in relation to Dubai court proceedings. And certain of the judges have shown an appetite to grant that sort of relief, I have to say. In the early days, I'd say that there was really no interest in giving that sort of remedy, but more recently, perhaps there has been. And you mentioned, I mean, in the Hazram and Hayri case, in essence, Sir Jeremy Cook did grant an order. It was aimed at proceedings in Pakistan, but it prohibited anything outside the DIFC. So the effect of it was to prevent Dubai court or Dubai arbitration proceedings. But yeah, I mean, I take your point. I think you're right. It'd be interesting to see whether or not, if a party just continually made successive applications to the JJC, there might come a point at which the DIFC court snapped. But absent that, I think it's unlikely.
And finally, Tom, you've got 1 minute, a very quick answer to this question from Keith Hutchison. As between the JJC majority and minority, which has won the argument?
Well, I don't think anyone's won yet, but the minority view seems to be winning at the moment in the 2019 decisions, albeit not in a completely straightforward way. So it seems to me that the pendulum is swinging. I don't know if you'd agree with that. As to who is right, I have my own views on that, and I think I've already expressed them. But as to who is going to win out in the end, I mean, it's anyone's guess, but it looks like it's going in the right direction for me.
We should mention, Tom, that about a year ago, there was in draft a proposed amendment to the JEL, which had the effect of blocking up the Conduit and essentially abolishing the JJC on the basis of that compromise. So that may be a score draw. I don't know what your thoughts on that are.
Yes, I mean, I think that's got to be the right way to approach it. If you don't want conduit jurisdiction, change the legislation that permits it. Don't introduce a new body which undermines the independence of the court, it seems to me. And that, as you say, was what was contemplated. I have my reservations about trying to draft something which achieves that, though, because there's a real risk that if you get that drafting wrong, you cause other real procedural difficulties with complex multi-jurisdictional claims. You may end up forcing people to take action, or you may in the DIFC and elsewhere, and you also may end up turning the DIFC into an assets shelter for those who simply register a branch in the jurisdiction. So there are a number of consequences that really one has to be very cautious about. As I say, you call it a score draw. For me, it would be a shame. I think personally, in my view, conduit jurisdiction, at least parts of it, have been a real progress. They've been a real advance for the rule of law in this jurisdiction. So I would be sorry to see the back of them. But if that is the price for dispensing with the way in which the court's independence has been undermined, then I think it's a price worth paying. Well, look, thank you very much, everyone. I think unless anyone has any further questions, that is all we've got time for today. So I'm very grateful for you all attending today. And if you missed, as I said, the first one, then the video will be up. And I think a video will be up of this if you've missed any part of it. We will be back, I believe, in 2 weeks' time now. So there'll be a 2-week break. And we will be back dealing, I think the next one is on the question of arbitration. Is that right? Yes. Where we'll be joined by the author of that section. So thank you very much for joining us again. Gregor Hogan, thank you. And thank you again for joining us. And I hope you can come back and see us again in a couple of weeks. Thanks.